I want to make 5 points to explain not just what happened at Liverpool Magistrates Court and Liverpool Crown Court on the 30th of May 2025 regarding the Liverpool defendant arrested following Liverpool's victory parade, but also to explain briefly the charges he faces and the possibility of the Crown Prosecution Service, CPS, of bringing new and further charges. Point 1. The defendant is to be presumed innocent until proven guilty in a court of law. Please don't forget that. Point 2. There are important reporting restrictions imposed by Liverpool Magistrates Court and followed up by Liverpool Crown Court as reported. Those restrictions prohibit the identification of the 6 victims named in the charges so far from being published. Point 3. The defendant currently faces 7 charges reflecting currently 6 victims. These 7 charges centre on the vehicle being driven by the defendant, according to the CPS. The prosecutor said this in court. The defendant, say the Crown, drove deliberately at people amongst that crowd. The Crown say he, the defendant, used his vehicle deliberately as a weapon to injure those individuals. So the charges are 2 charges of Section 18 wounding with intent. The level of injury here refers to the breaking of 2 layers of skin, that is, bleeding of some kind. 2 charges of Section 18 GBH with intent. The level of injury here refers to really serious harm, e.g. breaking of bones. The defendant also faces 2 charges relating to attempted Section 18 GBH with intent and 1 charge of dangerous driving. These charges were authorised by the CPS, who bring prosecutions against the defendants because the CPS believe the 2-part test to those current 7 charges are met. Test 1, the prosecutor believes there is enough evidence against the defendant to provide a realistic prospect of conviction. And test 2, the prosecutor believes it is in the public interest to prosecute the defendant, clearly taking into account the impact of this incident had on the number of people and communities. Point 4, the defendant was fast-tracked through 2 courts on the 30th of May 2025. Very sensible of the judges. In this case, the defendant at Liverpool Magistrates Court was not expected to enter or even indicate a plea, either guilty or not guilty, in relation to those 6 indictable charges, 4 Section 18 charges and 2 attempted 18 charges. In relation to the dangerous driving charge, this is what we call an either way offence. It can be dealt with either at the Magistrates Court or at the Crown Court. The defendant's case was then sent on the same day to Liverpool Crown Court. Here at Liverpool Crown Court, the defendant again did not enter any pleas, but the Crown Court judge gave very important directions, and these include to confirm those reporting restrictions for a pre-trial plea hearing, a PTPH, on the 14th of August, where the defendant will be asked to enter a plea to those current 7 charges and maybe more. And a trial was listed provisionally for the 24th of November 2025 with an estimated length of 3 to 4 weeks. And finally, point 5. The district judge at Liverpool Magistrates Court said the defendant was alleged to have caused very extensive injuries and there was a very real prospect of further charges. This comment reflects reportedly 79 people being injured. So it's expected that the number of charges the defendant will eventually face is very likely to substantially increase. Feel free to comment, but please do respect the reporting restrictions in the case. Subscribe and follow for more.